I put glasses on just to put them down. Welcome to Pop Culture Papi. Welcome to new studio setup. We got a little something different for you. A little something different. We got some different flavors tonight. Uh, Tonight's show, we're going to talk about a lot of things. I got a lot of good news. We got some bad news. We got a lot going on. Unfortunately, I did not know Nate was going live. You guys know I do not go live on Monday nights. It is usually a Friday night situation. But I read the headline that we were going to talk about today in a few minutes, and fired up Lori. I've not seen it yet, and I waited to watch it with you guys. Now, again, sometimes you guys watch this stuff, so I understand that you've seen it, so maybe it's a repeat for you. But sheesh, sometimes I just gotta wait for you guys. So we got a new studio set up. I'm glad that it turned out the way it did. This is looking a little crooked. Hold on. That's gonna bother me. But it's good to see you guys. So first, I'm gonna start with the good news. Then we'll get to the bad stuff with Lori, and then we will get to good news again. So here we go. I'm going to start with positives. Okay. Now, I don't like to get on and brag or do anything like that. And this isn't bragging, but this is something I am very proud of, and I'm excited to share with you guys. So I'm just going to share it. I'm excited to share it with you. Go back. So we've got, whoa, Colby, whoa, hey, slow it down. Okay, this is a good view. We've got merch for you guys. Kelsey and I both talked about what we were going to do with this, and you guys have asked me a lot, like, do you have any Star Wars merch? Is there ever going to be merch on the channel? And honestly, I wanted it to mean something. It needed to be symbolic. It needs to have weight to it. Now, we had a lot of funny ideas. We had a lot of ideas for you guys to make you laugh or add things in. I just wanted to show you the shop, what we got. So this is something Kelsey was working on. It's nice. She helped me with that. We have our Warrior shirts, and I wanted to give you guys a lot of variety. So if you click on these, you can pick different colors, but I think they look good. And honestly, again, you guys have been a part of this journey. Can I get out of that? You've been a part of this journey. So we have different things on here. We have some mugs. I like this one, and you guys are going to see me rocking all this stuff in the studio. So there's the white one. I just think that looks good. I think it looks good. So you guys know your Warriors. You've been a part of the podcast, and we have so much more planned and so many more people that we want to talk to and be able to inspire and continue to do what we're doing. So this is on the channel now, and it's for all of you guys, and we'll continue to add to it. I'll let you know when we're coming up with something new. But I was very excited by that. I just feel, I feel that it's just something that means something more, right? We're not just making t-shirts. We're making something that matters. We're part of a movement together. And so, yeah, just want to share that. And thank you guys who have gotten your Star Wars merch. Please send pictures. If you're okay with that, send it to askcolbyj@gmail.com so we can post it if you're comfortable with that and show you guys wearing your merch. Okay. I'm excited about that. Now, oh, Celeste out here got her Warrior sweatshirt. I love it. I can't wait. We're going to have all of our stuff here, guys. So I will literally be wearing this stuff constantly. You'll see tonight we went a little formal. We got a little something on there. What is that? All right. Jennifer says, Culpster, shout out to your wife, always having your back and standing up for what's right. Get him, Kelster. Kelster, I love it. I love Kelster. That's funny. But what we're going to do real quick is we are going to watch. Now, again, I'm not going to watch the whole thing. I always say this to you guys. We're not going to watch this. It looks like it's an hour 13. Now, I know with what Nate's going through, I listened to his, it was like a 7-minute video today, and he was talking about the situation he's in. I'm going to give you guys my inside perspective. I don't know why she's calling him. I don't know why she's calling Nate to be a witness. There's absolutely zero reason. The only thing that I think she's doing is calling him so he cannot report. And I'm not sure why, because there's a lot of other people who have talked about this. There's a lot of other reporters. And for some reason, she chose him specifically as a witness where he cannot help her at all. I don't know what her plan is, and I don't know what she thinks is going to happen. But I I'm just, I don't know. Sorry. I looked at a text from Kelsey. But I don't know what her plan is with Nate, and I'm not really sure what she's doing, and I'm never going to be able to figure it out. But I'm interested because it seems that there's a lot of different things going on in this trial. With her being in it, it seems way messier for some reason. I'm not blaming everywhere. I'm not blaming everyone else. I'm blaming it on her, and she's making it seem so messy. Just felt so coordinated and organized, and now it's just there's always something going on that's really weird. So we'll see what happens. Allie says, Colby, Lori showed her true colors in court today. Hugs, love to you. Love you too, Allie. She lost that today. Nate won't be testifying. Let's go, Nate. That's a horrible position to have to be in. And so I'm not sure what her plan is. So we're going to watch a little bit of it. If you guys know, again, when I do these reactions, I like to do them as raw as possible. So I have not seen this. If there is a timestamp that we can go to and kind of give our thoughts on specific things, you guys can drop that in the chat. I am going to pull it up to where I think this point is at, and we will watch a little bit of it. And then I got one more thing for you on the show, but I appreciate you and love you. Kelsey worked really hard on the design for my gals. So that is not me. That is her. And she did a really good job on the design. So I just wanted to say that one more time because they look really, really good. So I'm going to share this with you guys real quick. Okay. No, sure. Go ahead and take your sweet time, Colby. That's fine. We're not all waiting. Okay, here we go. Here we go.
But they're not bases to preclude a witness. The court finds that based on the state's avowal that those three specific witnesses do have some minimal, although very limited, relevant information to provide and could be helpful.
I'll switch to this.
To the jury in understanding the case. So the court will deny the motion
to
exclude the state's witnesses. Again, this ruling doesn't preclude you from any objections you may have to if they're testifying to hearsay or something like that. Next I have...
Oh, we can't hear her whispering.
Is there a Mr. Eaton here appearing?
There's no way I timestamped this perfectly.
Your Honor, Matthew Kelly, I represent Mr. Eaton.
Okay. You filed a motion over the weekend.
There's no way.
Mr. Eaton or someone that he works with filed a motion. Mr. Eaton was, let's address that now while we have people here. Mr. Eaton was listed as a witness by the defendant. Mr. Eaton apparently is a reporter in Idaho, and based on the filings, believes he doesn't have any relevant information.
He doesn't. Why
should
why
be listed as a witness? So let me ask the defendant, what relevant information would Mr. Eaton have? Why is he listed as a witness?
Well, I just got this last night, so I haven't had time to read all the things that he's claiming he doesn't. But
what?
There's several things off the top of my head that is relevant.
Relevant's not a word.
Right now, one of the things is it's different now, right? Because he's had this off the record conversation with the prosecutor. And he's kind of made himself a witness. He's kind of made her a witness.
How so?
How, Sway? How did he make himself a witness? You call the witnesses. How did he make himself one?
In the sense that if this is not prosecutorial misconduct, then one of them is going to have to testify and talk about how it's not.
Let's back
what?
Up. How is he a witness to this trial? How does he have
Guys, I swear to you, the thoughts that go through my head come out of the judge's mouth instantaneously. It makes zero sense, Lori.
Relevant information. Relevant information means a witness has testimony that makes some fact in the case more or less likely. So how does he have relevant information for what this case is about?
Okay, so initially when I put him on my witness list, my intent is because I do not know what the state is going to put on in their case in chief. And so I was calling him as a witness for the purpose of impeachment, laying foundation for interviews, rebuttal to whatever that the state might put forth, because he has interviewed almost every single witness on their witness list. And if they were to say something contrary to what they said to him on a public thing, then I would use him to lay a foundation for interviews and for impeachment. So that was my initial, calling him.
I gotta Google.
I found it funny when I read the beginning of this. He says that it seems to be clear attempt by Mrs. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report.
Okay, so hold on. I'm sorry. I look up the definition if I don't fully understand it. Impeachment says a charge of misconduct made against the holder of a public office or the action of calling into question the integrity or validity of something. So basically, let me, I'm sorry. I gather my thoughts live with you guys. So basically she's saying because Nate has interviewed people, they could go back and watch their interview and study it. And that way they could keep their story linear against her. And that basically I think that's what I'm gathering from it. I could be wrong, but that's what it sounds like she's saying. And she's trying to say, because they've all talked to her, they have the ability to go back and know exactly what they said, so they could all come together and form a perfect line against her as if she's not guilty. That what blows my mind the most and continues to blow my mind in these situations is how much she will fight against the fact that she is wrong. It's seriously, it's a skill at this point. It's insane.
So I had to laugh at that because it hadn't even occurred to me that he wouldn't be able to be in the courtroom if he was a witness according to 615. So that wasn't my intention. It was never my intention to do that. It was just to have him on hand if we needed to do that.
What?
All right. Mr. Kelly, right?
Yes, Your Honor.
Mr. Kelly, in theory, it sounds like if a witness said something different than they reported to Mr. Eaton at some point, I guess in theory, she's right that Mr. Kelly could be called as a witness to impeach someone, but that's only allowed after the person's confronted with the actual statement that was made, and if they then deny that statement that was made. Do you have copies of his interviews and transcripts of interviews that you might want to impeach someone with?
I've been watching most of the interviews and I take my own notes, so yes.
Oh, no mother effing way. If she's watching his interviews, she has access to YouTube. Am I the only one that's immediately assuming she's watching everything that I'm saying? I literally, I hope you're watching this. If you're watching this, let's just say, if you're watching this video, Lori, you need to walk in that courtroom, flip this thing around, let everybody go home and stop wasting our gosh dang time. You've been as disrespectful as you've ever been. Get out the freaking way, period. I hope she sees this. Stop wasting everybody's time. That's not even half of what I want to say, but let me just say right here, right now, she is watching videos on YouTube because that's where Nate gets it. Unless, okay, and this is a stretch, unless she's getting just the file somehow, someone's downloading these videos and sending to her as files, which I highly doubt. It sounds like she has free access and is able to watch YouTube. You're going to tell me she's not looking me up if she knows anything about it? Wild. I'm still biting my tongue right now. That's a good question. I'm assuming, right? Because Nate's interviews that she's referring to are on his channel. They're on East Idaho News. This is where he does the bulk of his work, from what I understand. I know he has a Facebook and things of that nature, and they have a website. But these interviews that I've seen are all on YouTube. So she has some kind of access in some way, somehow, to these either transcripts of them. Maybe somebody literally captioned every single thing that someone said and gave it to her. She has some kind of access to do it. I don't know. That's what I gathered.
Go ahead.
Your Honor, two things. One, excluding Mr. Eaton under Rule 615 would be a violation of his rights under the First Amendment to attend and report on this very public trial. But more importantly, Your Honor, if Mr. Eaton were to be called as a witness,
We changed it up.
the party calling him would have to comply with ARS 12-2214, which has very stringent requirements for subpoenaing and compelling the testimony of a journalist about information that that journalist has obtained in the course of news gathering. As we state in our motion, we don't believe that there is any way that Ms. Daybell can meet those requirements, but if I would suggest that if she wants to call him as a witness, she would absolutely have to follow the requirements of the subpoena law, and we would then have an opportunity to challenge that. But we don't believe that there should be any reason for Mr. Eaton to be excluded from the courtroom.
Find the shoe.
All right.
Where's Waldo?
I'm just thinking through this problem. If a witness got on the witness stand and said something different in testimony than you saw on an interview with Mr. Eaton, you would then play that interview. You wouldn't even need Mr. Eaton
Thank
to do the
you.
impeachment,
Yeah.
because
Oh,
you could impeach them with
you freaking.
the interview by playing it for them in court or something like that. So now that I'm kind of thinking it through a little more, I'm not sure.
And I wouldn't need him to lay that foundation for the interview.
What foundation,
I'm-
motherfucker? He's asking questions and they're answering it. You have all the stuff you need right there. All you're gonna ask is what's the foundation of what? His intent of the question? He interviews people for a job, for a living. What are you trying to baseline?
Really trying not to give you any legal advice because you are acting as your own attorney.
Legal advice.
If the witness admits that's them on the interview and that's their statement, that is foundation.
There you go.
So
He's interviewed law enforcement, almost all the law enforcement that's going to be, up here on the stand. So
How?
it's not just witnesses, it's law enforcement.
well, when I
He's
say
saying that the interview, why am I talking to her? I'm just telling you, it's so wild that she's even trying to make this case because I know nothing of law. And the simple fact is the foundation that you're bringing up is already evident in the interview. So you don't need him to clear anything up. The only thing he will clear up is what he already said in the interview, which is on tape, which you already have access to apparently.
witness, I mean generally any witness, regardless of their occupation. So I don't foresee, I see it in only the narrowest of situations where he could even be called to as a extrinsic person to
For what?
testify about the impeachment.
For what?
You'd have to jump through a number of hoops before that, as far as presenting the witness what the statement is, and depending on whether they admit or deny that it's them on that video or interview or whatever the case may be that you're
Exactly
referring
right.
to. But I'm inclined to strike him as a witness.
How do you put up with this?
At this time, allow him to be present if he so chooses in the trial. But then again, if you wanted him as a witness, you would need to subpoena him. But at this point, I'm going to strike him from the witness list and permit him to be in the courtroom. If there's a situation where you think something has happened during the trial where you think he should be called as a witness, I guess we'll cross that bridge when and if it comes. Okay.
Honestly, that is a huge win for Nate. And again, when I read you guys the list, the day that I got it and I saw that the first name was Nate Eaton, my immediate thought was, what are you trying to do here? And again, I think I shared my thoughts then, but my first thought was just trying to get him out of the courtroom, which I'm sure he's addressed as well. So I don't know, man. There's never going to be a point where I'm able to tell you guys what's going through her mind, but watching what she's saying is so crazy because she doesn't even make any sense in the sense of like, is no one around her saying what you're saying doesn't make sense. Is there no checks? I know she's her own lawyer, right? But there's somebody else to the side, like, hey, this is a bad play. Or is it literally just, all right, you go, girl, you get yours. I have no idea what's going on right now.
We could just call him up from the back.
Well, we'll address it when and if it comes. Yeah.
And Your Honor, I would ask that if
Real funny.
that were to occur, that I would be notified and given a chance to appear and be heard.
Well, everyone will get a chance to be heard if we cross that bridge. I just don't see us crossing that bridge, but I could be wrong. So at this time, it's sort of striking Nate Eaton from the witness list. He can be present if he so chooses in the courtroom.
Thank you, Your Honor.
All right, thank you.
I think that's as far as we're going to go.
Let's go next to the state's motion to preclude media from displaying or disclosing phone numbers and email.
Here, listen, what I told you guys at the beginning. I told you at the beginning. This is a long thing. It's an hour. Now I could sit here and listen to the whole thing with you guys. You know that. But do I want to do that? Do we really want to do that? Because that's a long time. And the thing is, this is what's crazy with the media thing. And I don't even know if we need to watch it for me to say this. The media thing bothers me the most because you on your own free will wanted the interview, which means you wanted to be seen in the public eye because you wanted to tell a certain story. And now you're mad about the fact that media wants to be a part of the trial. I just saw that she tried to get her case dismissed, and I can't figure out, like, it's not like, okay, I'm going to defend myself. It is everywhere, all over the place. I can't follow any line of logic here.
Email for witnesses.
We'll watch it for a minute.
Victims.
We'll watch it for another minute.
I guess I have no problem granting this in concept, but let me ask the state: are these people going to testify? This is my phone number, or this is my email, or it's going to be displayed up as part of the evidence on the screen, or both?
Your Honor, it would be both. Some people would have to testify as to their phone numbers or emails that would also then to establish the foundation of then conversations that are on text messages, emails, iCloud accounts. So my concern obviously is there are both victims whose information could be displayed up there, and I think the Constitution allows them to request that not be displayed. But additionally, just for safety concerns, given the high profile nature of this, for witnesses who have, several of them have attempted to not be part of the media and have not given interviews and would not want their information to be out there, given that this is being live streamed, having their phone numbers or email addresses live streamed out there to the world. I would ask that not be done.
All right. Does the defense want to be heard on any of that?
Is this how the camera view is going to be?
No,
the
we
whole time?
agree.
So we're not actually being live streamed, but there's a 30-minute delay order on broadcasting what's in the courtroom. I already have a protective order that jurors can't be broadcast in any way. And I have an order that the feed can't broadcast sidebars that we might have. So I'm going to order that the feed also, to the extent you can see it visually on an exhibit or something, they shouldn't film someone's phone number or email. And then I don't know if the right person's here. Do we have the ability to, does the media have the ability to bleep out or silence if someone says my phone number is 480 blah blah blah? We'll find that out before we start the trial. But that'll be the order. As for anyone that's doing print or podcasts or anything like that, you're prohibited from reciting an entire phone number or an entire email. You can use the area code, or you can use a couple digits at whatever, at live.com, at outlook.com, but I don't want their emails broadcast or reprinted. Let's go to
Yeah, this is just for the jury, I think.
state's motion to preclude Lonnie Dorkin and preclude noticed witnesses.
Poor Lonnie. Lonnie, okay, hold on. I think we had our chat last time. I'm so sorry, I forgot who said it, but she said good old Lonnie Dorkin, and it floored me. So thanks for that. Now I can't
Did Dorkin ever get a report prepared?
I'm not even trying to disrespect Lonnie, okay? But when she said that, that was it for me. Okay. Now every time I hear that name, it's over. Lonnie Dorkin. Okay, sorry. I'm not making
Not
fun
that
of
the
her,
state
I
has
promise.
received.
Do you know?
Oh, she's in court clothes. I didn't even realize. Oh, this takes a long time. Huh? Let's do a little speed up here. A little speed run with it. There we go. That's a total. There we go. Oh, here we go. Come on.
Was working on a bunch of information that was
I'm sorry. I should have just slowed down. Yeah, but that's what doesn't make sense to me. The
So-
media thing. You love it and you hate it at the same time.
okay.
Doesn't make any
Your Honor,
sense.
most likely, we're having an affidavit sent over from Mr. Dworkin tonight. He has found a discrepancy in the information that he downloaded and the information that was turned over initially by the state. And he wants to explain what that is and how that will be relevant. So if we get it tonight, we'll forward it immediately to the state, of course, tonight. He was working on a bunch of cases and he's doing the best he could to include our case and get it done as quickly as possible as when he was assigned from OPDS.
Well, at this time, I'm inclined to preclude Mr. Dworkin, granted something pretty extraordinary happening. I offered you a continuance last time.
It's
we
not
were in
funny.
court
It's just the Dorkin
in
thing.
order
man.
for you to explore that possibility. You declined the continuance. So it's any disclosures late at this point. I'm not going to slam the door on it completely because he may or may not have anything that actually ends up being useful.
I've not seen this
But
yet.
at this, if depending on what he actually has, we can talk about it. But at this time, he's likely to be precluded as a witness because the state wouldn't even have an opportunity to
You guys make me laugh.
have
This is-
their own witness.
Let me just say this. You guys make me laugh. Your chats make me laugh. I got to be careful because then it looks like I'm laughing at what's happening. I'm not laughing at that. I'm laughing at your guys'
rebuttal
chats.
witness look at something prior to trial. But again, depending on what you have, we can talk about it again.
Okay.
The rest of your witnesses, we've already talked about Nate Eaton. I don't know if we need to go through each and every witness, but I think where I need to start is if a witness hasn't been served with a subpoena to appear in court, there's no requirement for them to show up for your trial. If they have been served, they would need to submit to an interview with the state in advance of their testimony. And then the third aspect is they need to have something
Okay, hold on.
relevant.
Ray's asking who's Dorkin. Well, from what I understand, Lonnie Dorkin. Stop. I can't. Somebody ruined that name for me forever. Dorkin is apparently from the last one we watched. Lonnie. Okay, Lonnie. I'm not making fun of you. I swear to you, I'm not making fun of you, Lonnie. I swear to you, I'm not disrespecting your name. It just got attached to it just was said at the wrong time. Okay. Slow chat. Slow yourself down. You're gonna make me laugh. I'm trying to get through it. Okay. I gotta answer Ray on this. Lonnie, okay, Let me take a deep breath. Lonnie Dorkin. Hold on. Stop. I'm not playing right now. Lonnie Dorkin does media. He does media searching. I think he I'm trying to gather myself. This is not funny, bro. This is not this funny. So Lonnie, thank you. She saved us. Okay. There you go. Okay, Dorkins for the media. Okay, he does media stuff. He's a researcher. He's going in and he's going through the stuff, and I don't know if he's heard defense. If there's a lot going on right now, you slow down. He goes in on her defense, I think, and is going through tons of this text. Frick this, man. I'm not even trying to talk anymore. I gotta watch this. I'm done.
To testify about, which relevant, I told you a little bit ago, means they have a testimony that's not based on hearsay, that tends to make either a fact more likely or not. So why don't we go through, I'm trying to compare your witness list to the state's motion.
This is not this funny.
Let me see here. So Nate Eaton, as of now, is not a witness. Next, we have,
Not that funny.
I don't know how to pronounce her name. Is it Viasia?
Vicia.
Vicia?
Okay.
Iha.
That is so effed up, and you have no idea. Okay, this went serious real quick. We got over Lonnie. She's calling Tylee's friends. Why? This isn't about Tylee around here. So I really, really don't understand why she's calling them. I don't understand. And that's so unfair to Vicia.
Is this one of the ones the state was able to get a hold of?
No, Your Honor, we did call the numbers and left voicemail. I've not had any response, and it's my understanding that when I interviewed the defendant's investigator, Jeff White, he also was unable to speak with her.
All right. What about Gabriel Bonilla?
Your Honor, I had an update on that one in the sense that on Saturday, so when the state interviewed, again, Jeff White, the defendant's investigator, he had not been able to speak with Mr. Bonilla. I also called and left a message on the phone number that I received from the investigator. On Saturday, the attorney for Mr. Bonilla called me, and Matthew Ballard, who represents the Church of Latter-day Saints. He advised me that Mr. Bonilla has not been served with a subpoena, but I did not speak with Mr. Bonilla or was not given an option to speak with him.
So we don't know if that.
So I already got over Lonnie. I get a text. Stop it. Stop freaking texting me, bro. You're freaking killing me. I get a text from Kelsey. Lonnie Dorkins sounds like a hobbit. And then Ray, if I'm ever a male dancer, my name is going to be Lonnie Dorkin. You cannot do this to me. I'm about to throw my phone out the freaking window, bro. Oh my gosh. I can't check my phone. I can't look at the chat. You guys are killing me right now, bro. This was not supposed to be this funny to me.
Person's
not
been
that
served,
funny,
or if
bro.
they have
This
relevant
is
information.
Too much. I
According to the
forgot what we're
attorney,
here
Matthew
for.
Ballard, he has not been served.
All right.
I'm not even listening to it now at this point. All I can think about is trying not to.
What about?
I'm sorry, Lonnie.
Well, let me.
I'm really sorry, Lonnie. This is not. We're not making fun of you.
Why don't I just ask the state? I've got your supplemental and your other one. I know you've actually talked to a few of these people on the phone.
Correct.
Is there anyone
breath.
on this list, and I'm looking at the defendant's supplemental 15.2 filed March 12 on page 2, there's a number of witnesses listed out. Is there any on this list that you have talked to that you don't object to being called?
Your Honor, I think that there is potentially minimal relevance from Summer Shiflett.
Chislett?
I think that's a misspelling of her sister's name.
Okay.
I think
Hit him
there's
with the
potentially
shizlet.
minimal
What
relevance
is happening?
for
This is not supposed to be funny. How did you? Oh man, what the hell is happening right now, bro? Shizlet. It's like a slur. Yo, I need to
Janice
breathe
Cox,
right now. This is
her
not
mother.
supposed to be funny. This is a
Okay.
court hearing.
Adam Cox is actually on the state's
I need to
witness
breathe.
list,
I
so
need to
we don't
breathe.
object to him.
Shizlet, man.
I did speak with Zachary Cox.
Okay.
I'm not aware of any relevance as to this case from him, but I did speak with him.
I see in your pleading that he advised you he's not been subpoenaed.
Correct. Everyone I've spoken with has not been subpoenaed.
Dang,
Right.
Lori.
Your Honor, our subpoenas are with OPDS right now, and they should be
Lacking.
being issued currently.
No one should have
you
to
know, the
do
state
this.
talks
No one
about-
should have to speak on her behalf, and this case shouldn't exist. But apparently we're getting some really, really good comedy. I didn't even expect for us to watch
And
this
their
part.
response, like,
You already know. I said it
state-
earlier. I even said it.
is claiming trial by ambush from the defense. Trial by ambush. How is the defense trial by ambush when they have interviewed every single one of these witnesses before in the last
look
5
that up.
years since this case started? They've interviewed every single person that has been on there. They have written, transcripted interviews and video interviews of all of these people. And so how they are relevant, these witnesses will testify if and when they are needed to add additional facts or fill in the blanks that the state will no doubt leave out in their case in chief, and they'll be called accordingly. I need them to lay perhaps foundations for evidence presented by the state. The same with Lonnie Dorkin. I need his testimony will be required if and when it's necessary to rebut digital information that the state will bring forward during trial. I feel like the state is trying to say, okay, if you want your speedy trial, guess what? We're not gonna let you defend yourself. Guess what? You can't have any experts. And guess what else? You can't.
That's hurt right there. You want to see what it's like talking to her? That's it right there. I've seen that a million times flip over. That switch is so quick, you never would believe it. You'd be having a normal conversation, and then it's a million miles, full water, the dam broke, and she comes flying, bro. She's obviously mad, but she cannot control herself. That's it.
Have any witnesses. You can't have anybody speak in your behalf. So good luck. Have a nice day.
Yeah, have a
All right,
nice
well-
freaking life, motherfricka. It's not about you. You're wasting everybody's damn time. Why don't you shut up?
That's why attorneys sometimes take a long time to prepare for a trial, because they need to give notice of what all the testimony their witnesses are going to give. They need their experts to prepare reports. That's why your prior attorneys and your current attorneys were asking for more time to prepare the case.
There you
So
go. He's right. This man is killing her softly. He is so non-reactive. He sits there and he just says, this is why. I mean, this guy's a thug, man. He's a real thug, because he just is so cold in the best way. He doesn't react. This is some serious alpha stuff right here. Colby, was she like this in real life? I bet it gets worse. I bet her evil just spewed out. That's a whole nother conversation for a whole nother time. One thing I will say is I think that to deal with her, you have to be like this. You have to you have to be non-react. If she comes at you 100% and you give nothing, she can't bounce off of that chaos. And so therefore I don't know if you could say the word she calms down, but you need that.
You can't really have it both ways, that you want your speedy trial rights, but you don't want to give notice to the other side of what your evidence is.
I don't not want to give notice to the other side, but the limitations at the incarcerated state where I am, and the limitations with OPDS of getting Lonnie Dworkin late in the game that they did, I've done everything in my power as a defendant to prepare the state and to give over everything that I could do within my power, with the limitations that I am an incarcerated person at this maximum security prison jail.
So when you say,
And I shouldn't be able to represent myself because of that fact.
Oh, you don't want me to, I'm going to take another note from the judge. Take a deep breath. I'm not going to say nothing.
That negates my constitutional right.
I didn't say that. All right. I said that sometimes there are reasons to not go forward to trial as fast as you want. All right. So when you say things like they're going to fill in the blanks, that makes it really hard to assess what their relevant information is.
They have relevant information to a lot of factors that I got in the 404B information. For example, the life insurance. My father is a life insurance salesman. He worked with Charles on getting both life insurance policies, my $2 million policy and Charles' $1 million policy. He also tried to sell my insurance policy after Charles passed away. He also told me to go to call the insurance policy and said how to do that, how to call them when you're the beneficiary. I didn't know how to do any of those things. He has relevant information to that. My sister has relevant information to my brother, Alex Cox, and the whole situation of what happened on July 11th. These people have relevant information to the state's case, what they're accusing me of. There's very relevant information from a lot of these witnesses.
So what I'm struggling with is you just saying that it's relevant doesn't actually make it relevant. It may be relevant. I'm trying
There's nothing better than this dude. I'm telling you right now.
to find out the relevancy. What you said about your father being an insurance salesman and selling policies, that sounds relevant. It could be relevant to me. Who's your father? I don't know who your father is.
Barry Cox.
All right, Barry Cox. It sounds like even from what you're saying, though, you're not, depending on what the state produces at trial, you're not sure that these witnesses would have relevant information. It just depends, is what it sounds like.
Whatever they put up in their case in chief, am I not allowed to try to defend myself against that?
Stop asking that question. You already are.
You're absolutely allowed. I'm just trying to figure out, I'm sort of a gatekeeper, and I need to make sure witnesses have relevant information. And just like you have the right to interview all of the state's witnesses, excluding victims' rights, people that can deny having an interview, they have the right to interview all your witnesses prior to trial so they can have an idea of what those witnesses might say on the witness stand.
I understand that, Your Honor.
So
They also have already interviewed all of them.
I'm not talking about police interviews or interviews that may have been done years ago. The prosecutor has the right to interview any witness prior to them taking the stand, just as you do. So I'm not sure the best way to handle this, other than maybe we should take it up as we progress through the case, but
Your Honor,
some of these people may or may not be even served.
Yeah, my concern is, obviously, I have attempted to reach these people. I've made my good faith effort. I've been told both by myself in attempting to contact them, as well as the defense investigator, that they've been unable to reach them. So it seems
I feel bad for them, bro.
to not be following the rules of procedure or evidence, to then bring up later on, if they perhaps find these people at some point, then the state can try to, at that point, preclude them. When the state talks about a trial by ambush, it is in fact that. When the defense investigator themselves cannot find these people and are still looking for them in trial when they've had at least, we'll say, 4 months to try to find them, I think that at this point, precluding them is proper.
Well, I would preclude anyone that doesn't submit to an interview with the state. I kind of want to punt this a little bit, just because if there's people that don't end up getting served, don't end up showing up at court, they can't find, then we don't need to waste our time talking about whether or not those people have relevant information, because they're not going to be here and they're not going to testify. So I'm putting the defendant on notice that if these witnesses aren't served, if they don't submit to interviews, they're going to be precluded. Even if they submit to interviews, I may have to make a determination whether their testimony's relevant or not. So again, we're going to, I think, have to cross that bridge when it comes. The state did say that they concede that some of the witnesses, Adam Cox, Janice Cox, Summer Shiflett, may have some minimally relevant information.
Isn't it?
The rest of these, I think we're going to have to take up maybe on a piecemeal basis, but I don't want it. It's not going to be a situation where you're ready to call them in as a witness the morning of, and then the state they haven't been presented to the state for an interview prior to that. So keep that in mind when coordinating with your investigator. If he gets them served and they're actually going to be called at trial, they need to submit to an interview in advance of their testimony.
Your Honor, I understand that. And I am limited in what I can do. If I could call these people myself, they would answer my call probably, and I could have this discussion with them. But I'm going through the limit.
You know what? Okay. And this might be right close to where we ended. Okay. The thing that's wild to me is that she sees herself the same way that she always has seen herself, meaning nothing has changed in her mind. Like, she thinks that everyone looks at her the same way as they've always known her. And she keeps holding on to that. I've heard her say that to Summer in that phone call she made to her. She says to people, you know me. And there's some part of her that's trying to like have this credibility of who she was, because I think she knows she changed. I think she knows how different things are, but she's still trying to pretend like they're not. I think it must be easier for her to act that way and pretend that it's not different in her mind. So when she's like, oh, well, they'll take my calls. Are you serious? Do you really think that this is the same? Like everything's the same as it was? And I think that whether she caused a lot of trauma, and I think she traumatized herself. And I don't feel bad for her, but what I'm saying is this is crazy behavior to think that Tylee's friends want to talk to you, that your family is in the same place as they were before, and that everyone looks at you a certain way and thinks of you as if you did nothing wrong. And she's acting as if she did nothing wrong. So I think she had to come up with the backstory as she did to tell herself, there's nothing wrong here. There's nothing wrong with me. I've never done anything wrong. And just the way she moves and talks still just shows you that that is relevant right there. So I'm not gonna lie to you. We watched a lot of this. We had some good laughs. I still got one more part of our show to get to. I don't even know how to put my head on straight here. And look, here's the thing. It's not supposed to be funny. Okay. And I'm not saying that what happened is funny. You all know that. I say this every time because it's not funny what happened. But this is the most ridiculous thing I've ever seen in my life. This is absolutely crazy. And it is beyond a bad dream for everybody involved. But most of all, you have to see and give credit to that judge for being able to withstand that, right? You have to give him credit. And some of the stuff they say is funny. And yeah, exactly. It's one or the other in situations like this. You're literally either laughing or crying. So Hold on. Is there encores out here people want to keep watching and never dying? Listen, we still have one more thing to talk about on the show. We've got another 20. Okay. Give me a 1 in the chat if you want to watch the rest of it. And I'll give you my thoughts, honestly. Because I wasn't going to make this the whole thing. We'll still talk about what we have to at the end. Just give me a 1 in the chat, okay? If you really want to continue watching the rest of it. Because it is just a few more, maybe 20 more minutes? Oh, the ones are coming in. The ones are coming in. Okay. The whole chat's filled with ones. Okay. I'm not going to deny you. I'm not going to do it. We'll watch the rest of it.
Limitations that I have at the jail through my paralegal who's working overtime and my investigator who's working overtime to try to do everything to help me prepare for trial, as they have other clients as well that they have to do things in a timely manner for. So
you got me.
We are doing the best that we can.
We're going to do what the chat wants to do.
All right. We next have defendant's motion to dismiss for violation of confidential communication and the Sixth Amendment dated March 18 of 2025 and the state's response. Let me ask the defendant first if you've received the state's response.
I did.
Did you say you did or didn't?
I did.
Okay.
Yes.
If you have an attorney in Idaho that is working on an appeal, it appears that the information that was turned over by the jail was some pretty innocuous messages about trying to set up the legal line to talk to you on a confidential line. And really that's about it. So how does this arise to some sort of nefarious interception of things? Because it was put on a public chat system that the jail uses. You know it's not confidential, and you're told it's not confidential. And then even if I look at the substance of the messages, there's really nothing in the messages that would arise to some sort of confidential communication, just trying to set up a meeting and get the unrecorded legal line set up.
Who's saying that they're not
That's
confidential?
the link I sent for you guys for the merch.
Well, the
Who's
jail,
telling me that they're not confidential?
your own attorney, it looks like. Here's a message. I see that they came and got you. I'm working on getting a confidential attorney line set up. The implication being that this message is not confidential. The next one, again, just checking in. Hope things are getting a little better for you. I'm still working on getting a legal line set up. The implication is that these are not confidential.
Okay, so then he received a letter from MCSO that said, your phone number is now confidential and arranged for privileged, confidential client privilege communications. So
Phone
from
calls.
my no, it says this phone number
Man,
is
she's
connected to
rude.
that. So from my perspective, when I call someone on the tablet or when I text someone on the tablet, it goes to their phone number. So all the communications after the date of the exhibit that we put in our motion, when he got that letter from MCSO that now all of your things will be confidential.
Okay.
Now they will be confidential. So my understanding, and I'm the only one that can waive that privilege, right?
And I think after that, when his line was approved, there were no other disclosures of messages between you and him, correct?
No, there are.
Very long.
You received other disclosures of intercepting messages between you and him?
So those go up to the 24th of January?
No, the only thing I saw was up to,
Love that.
I think, late December of 23.
Okay, so there are confidential things that are in our communications because I was not aware that after he received that there were not. So the prosecutor who obtained these, her protocol would not be to stop and ask the court for some guidance on this, maybe do an in-camera review. If she's subjecting herself to client privileged communications, instead of reading them and finding out and assessing for herself if there are anything in there that's confidential information between me and my appeals attorney, I have no other way to communicate with him when I'm in this incarcerated situation, because I was brought here to Arizona to deal with these charges. So it is a problem. It's a problem that she took them. It's a problem that she got them from MCSO. It's a problem that she read through them. It's a huge problem that she put some of them into her motion, and now his IP address is exposed to the public, which is a federal offense. There's a lot of things wrong with what has happened here.
Well, you reminded me that when his number was approved, he then sent messages from different IP addresses instead of that phone number that was privileged. So he's the one that disclosed or violated the confidential nature. I don't see that any of these, I'm going to call them inadvertently intercepted messages between you and your appeal attorney. I don't see that they're being used in any way by the state.
Just the state reading them as a violation of the client attorney privilege.
Well, not if they're not done through a privileged setup the way that they were supposed to, which he even acknowledged.
My understanding from my perspective was that that phone number was now privileged. The way it comes to me on the tablet is I text that phone number, or I call that phone number.
Correct.
So,
if you're communicating through the phone number, but if he has it set up where the messages aren't being sent and received actually through the phone number, but through different IP addresses, the system doesn't know that they're privileged because they're not being sent and received through that privileged number.
But I didn't know that. There's no way for me to know that from where I am in my cell. There's no understanding for that.
What?
I assumed he was
when
just
you
getting
talk, it doesn't make sense. It doesn't make any sense.
them on his same phone that we were having client attorney privileged communications.
He already made it.
And is the state giving these to Idaho? Do these get dispersed out? I would like to know that. Where are these going? They're getting them from MCSO. Is there a subpoena to get these from MCSO? Is there a warrant to get these from MCSO? I didn't see anything that warrants them getting them from MCSO in the first place.
No response.
All right, let me hear from the state.
I think that the state's motion really covers the law under this.
So-
The defendant and her attorney were provided with information, whether or not she understood it or not. Her attorney understood that it was phone calls that were covered. So it's not just the defendant who is not complying with following the correct procedure to utilize the set up attorney-client privilege means to communicate. In this case, the state, obviously, I disclose those before I even look at them. I understand that they are statements by a defendant, and I believe that they are to be disclosed under Rule 15. And so before I even look at them, I send them to the defendant because I don't have the option of not providing them to her since they have been obtained. I think if you apply the case law in this, the defendant cannot meet her burden to show that
It's like 15 more
there's
minutes.
any legal advice in these messages. There's no privilege in them. The messages are asking to set up times to call and to speak.
Are the three, I think it's 3 messages that you included in your response, are those all the messages?
No, Your Honor, there are other messages, and we do say that tablet messages between Ms. Daybell and Mr. Jerem do not end on December 28th. They continue.
And there is privilege information on them going forward. And the state is basically testifying for my attorney now. She just testified for my attorney that he understood that they
Right.
were that these were not privileged communications. Where does she understand that where is she testifying for my attorney?
Well, I think because the context of the messages say, I'm trying to schedule a time and I'm trying to set up a confidential line, meaning
That was
this is not
before.
confidential.
That's right. He said it wasn't confidential
I need one too.
before MCSO gave him a letter saying your phone number is now confidential. Your phone number now has.
Okay, I'm not going to keep rehashing this with you. The fact that he's using different IP addresses and not messaging through the actual phone number that's protected, I think is part of the problem. So if he's not using the program correctly, that's an issue you need to take up with your attorney.
We know this guy is unbelievable at being calm to the situation. The fact that he lost it says everything you guys need to know.
How is
This
he
would be-
using it incorrectly?
I just
Dude,
told you.
she's so
He's not messaging through the phone number. He's using different IP
How
addresses.
can you message other than the phone number? I don't understand that.
I don't understand that either, but if it was from the phone number and it's for his cell phone, for example, it would be the same IP address for each communication. There's like 4 or 5 IP addresses.
Where are the IP addresses coming from?
there are different places where you're connected to the internet.
They're given to you by the state?
They're right there listed on the messages.
I'm just saying, where are they
I'm just
obtaining those
saying
from?
what? Oh my gosh.
From
it's
your
gonna make me
attorney's
vomit.
messages to you.
From MCSO?
Yeah.
Did they get IP addresses for every single person of every single message communication on the text from MCSO?
Well, it's listed on the messages, so I assume so. It says Craig Durham, and then under it is the IP address from the device that's being used.
Okay, and then Miss K is reading all of these messages and they're not privileged. Is that what you're coming to?
He
They're not-
answered your gosh dang question a long time ago.
Privileged if you're not using the program or your attorney's not using the program correctly. Okay, they're still not going to be allowed to use any of these messages. What I'm saying is they're inadvertent disclosure by
That's
MCSO
what the class is
because
for.
someone's not using the program correctly doesn't mean that they had bad faith in how they got them. They made
How is he using it incorrectly?
I don't know how else to explain it to you. I've told you 5 different times. now.
Thank you.
So
Thank you.
he's not messaging with the phone number. He's messaging from different IP addresses.
Okay, can I ask if these messages are being disseminated anywhere to Idaho, to the prosecutors in Idaho? Because that's definitely affecting my appeal if that's the case.
I don't know.
Have not been sent to anyone other than the defendant, Your Honor.
All right.
This is tough, dude.
So
You think that this is bad? This is the next long while. This is it.
there was
The everyday.
some communications I find that were intercepted between Ms. Daybell and her attorney. The state's not to use those communications. They're not to disseminate those communications, but I do find that they weren't purposely sought out by the state. And that dismissal isn't the appropriate sanction if there is an appropriate sanction. It's order denying the motion to dismiss for violation of confidential communication. All right, then we have defendant's motion to dismiss for prosecutorial misconduct dated March.
Ooh, this is what I was
21st.
I was wondering if they
That.
addressed this. This is the misconduct, she said.
And the state's response. The motion to dismiss for prosecutorial misconduct was filed on March 21. The response, I don't see a date on the response, but I do have the response. Did you get that response? Ms. Daybell, did you get that response?
I did, Your Honor.
All right.
This is tough to watch. I'm not gonna lie to you. Can we?
So your prior attorneys had actually, let me back up. The state filed a motion back in, I think it was September of 2024, asking the court to preclude your defense team at the time from making public records requests through Gilbert and/or Chandler police departments. I denied the state's request, saying that the defense is free to do their investigation and make public records requests through appropriate means. So that's part of your complaint, that they didn't provide those public documents to the defense. That's sort of a civil issue, I guess, but let me hear your argument on that.
That isn't really the complaint itself.
That's your first paragraph.
I know, but the complaint is that
I'd like to take each
Can you?
allegation and deal with them one at a time.
I can't.
I understand that.
believe it.
My
Allegation.
complaint is the interference by the state, Ms. K in particular, in stopping that and interfering with us trying to investigate and do our own investigation. It is a violation of the constitutional right and due process. And she did do it, and she did do it purposefully. And then after she did it, and we weren't allowed to have anything from either of the police departments, then she filed her motion. And then later, the day that I was Rule 11, that is the day after when you said that you denied that motion. So I don't know what she did or what she said to Chandler and Gilbert to stop them from giving us any information. But as soon as we put in a request, we were cut off. No information. You can't have anything. That's when I was trying to, the big video that we're trying to get in Gilbert, that's what I was trying to request. I tried to request that myself because I would have my investigator to go and explain what that was and why we didn't have it. And so we were precluded from doing all those things by the state. They should not be interfering with that. That's one of the reasons why everything has taken so long. We haven't been given things we've asked the state for. We haven't been given them. We tried to get them from Chandler and Gilbert. We can't get them from them. She's stopping us from getting from them. How are you supposed to put together a defense?
So when your prior defense counsel put in that request back in September, the state says that they obtained those information and gave it to your attorneys on October 1. So why are we waiting until March to address this if you had an issue with that?
I have had an issue with it the whole time. I've
So
been
why
taught-
didn't you why didn't someone file a motion back in after, December, November, January, February, saying they had an issue with this?
I did. These are in my motions to you for specific discovery. I discussed this exact problem.
Okay. Well, now you're saying it arises to prosecutorial misconduct.
It is.
This is the first I've been made aware of that, as far as I know, that the police department never honored the public records request. If they don't honor a public records request, there's a process to go through regarding that.
Which is what?
Oh, rude
I'm not going to give
motherfucker.
you legal advice.
Oh man, you're getting
All right.
wrecked, bro.
Your
Just
second
stop.
allegation, the prosecutorial misconduct, we've already kind of dealt with, that she distributed the state distributed attorney-client privileged communication. We've discussed that. The next one is legal advice to defense witness Nate Eaton. We've somewhat discussed that, but I think their motion, the state says that they simply notified him that he would need to be served with a subpoena to have to appear in court. So how is that improper?
Dealing with that right now.
It's taking her word for that that's what happened. She's not under oath saying that that's what happened. Nate Eaton's not here to testify that that's what happened. They're the only two
You
parties
just flashed your notes to the gosh dang camera because you picked it up above your gosh dang head, you mother
that
hecker.
are there to say that that is what happened. So that is my problem with it. I would like for one of them to get on the stand and say exactly what happened in that conversation and that she wasn't giving him legal advice. How do we know that she wasn't? It's a very curious situation that he called her, and then he writes in his motion this statement that obviously comes from Ms. K. She seems to be a clear attempt by Ms. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. We also don't know if he told her, don't come to the March 18th hearing because that's when they're going to serve you with your subpoena. So all these things come from there, and we don't know who's saying it. And you're just taking her word for it, like you took her word for, oh, there's only 6 emails and there's no other emails. You're just taking her word.
She is a prick.
For it as an officer of the court, and I think that she should have to be sworn in.
Well, you want me to just take your word for he must have gotten these things from Miss K, okay? Just because his motion says he thinks that you're noticing him as a witness to keep him out of the courtroom. I don't know why you take the jump to that is coming from Ms. K as opposed to his own volition. He also hired an attorney that said the same thing.
What is going on right now, bro?
Even if she had said you need to be served with a subpoena to have to show up in court, that is not an ethical violation.
Well, giving legal advice is an ethical violation. Is that correct?
What?
Stating what the law is not an ethical violation. If she said, I don't think you should show up at court, even if you're subpoenaed or something like that, that could be an ethical violation, but we don't have that.
I don't want to sit here and act like I know everything, but I told you guys how bad this was going to be. But this is actually worse than what I assumed. I knew she'd be rude. I knew she was going to be who she was growing up, but this is like even more. This is worse because it's not like it's worse. It's just worse. I can't put it into context.
How do we know we don't have that? That's my question. How do we know what went on in that conversation if it wasn't recorded?
If you want to know, and I'm going to just hit the hot button topic real quick, just so you know, if you want to know if this is what I grew up with, the answer is yes. Okay. And this is why I would be like, this is the most erratic thing. We would have a conversation and she would immediately respond like that. And you can't figure anything out if that's what you're going to get back. You say something and I try to keep it calm, say something. And I learned how to be passive because I never wanted to trigger her. So I learned my whole life how to work around her emotions and make sure I never, ever gave her my point of view because she would have reactions like that. So I remember telling her, hey, you can't come to the hospital right now because you're sick. And we just had our daughter, Riley, when she was our first baby, and you are sick and you can't come see her. And she goes, so you just are never going to let me see her in your whole life. And I'm the worst mother that ever lived. And you're never going to let her see me. I was like, what are you talking about? How is that anything of close to what I said? You mother hecka. For all the sacks, you need to get through this. Thank you, Allie. Okay, guys, we're almost done. Sorry, I went on a little tangent there. I just had to get it off my chest.
Aren't witness.
You can interview him. You can interview Mr. Eaton. Your investigator can interview Mr. Eaton. So when and if you get that information from Mr. Eaton that something nefarious happened in that conversation, bring it up then. But you're jumping to conclusions. You have the right to interview any witness, okay?
Not a witness anymore because you just precluded him.
All right. You can interview him. You can have your investigator interview him.
So even though he's not a noticed witness now, we can still interview him and try to find this information because we can't get it now. Is that what you're saying?
Sure. Have your investigator call him. Ask him about the conversation. At this time, I'm going to, based on just the pleadings, I'm denying the motion to dismiss for prosecutorial misconduct.
Of course.
Of course. She goes,
all right, 609 motion.
You are acting like a victim, and it's just so ridiculous.
Alleged a total of 7 felony convictions in the state of Idaho. Under Rule 609,
of course,
the court finds that limiting the number of convictions and the nature of the convictions to be appropriate as to not be overly prejudicial. there is an interest in allowing a jury to know that the defendant's been convicted of at least one felony. But let me hear, I'm inclined to probably limit it to 2 felonies in order that they be sanitized. Does the state want to be heard on that?
Your Honor, I do
I
believe
don't know what
that
that means.
the court should allow for at least 3. There are multiple dates
You're a real one, Kelly.
and multiple victims in those and multiple different distinct incidents. And I believe that it would be appropriate
Exactly.
to, when we're talking about the credibility of the defendant, to allowing in 3 of those.
I looked at the date ranges and I looked at the actual counts, and some of the counts, obviously the laws are titled differently in Idaho, but there's a couple of counts that specifically have what I would call dishonesty built into the name of the conviction, the first-degree murder and grand theft by deception.
Yeah, it's almost over.
Those are counts 1 and 3 specifically. And again, these only become relevant if the defendant chooses to testify. I did read the defendant's response asking that all of them be precluded. Let me hear from the defendant.
Oh, gosh. This is why I can't sit here and do this every day with
One
her.
second, Your Honor.
I couldn't sit here and do this and listen. It's draining. You don't even have to know what it was like to experience it right now. It is so draining to deal with this person. Seriously. You know what? That's a great point. I appreciate you saying that, because it almost makes me feel like I'm not crazy. She's crazy. I'm not crazy. She's crazy. That's from a movie. But anyway, it is really crazy because,
Your Honor, I haven't had a
Oh.
time to, I wasn't planning on talking about the 609 today, so I'll just refer to my reply.
Well, we can table it till later in the trial because, again, it doesn't become relevant unless you choose to testify, but you know my inclination and what the state's argument is.
Okay.
This morning I handed each side proposed preliminary instructions.
all right, we don't care about this. All right. Well, I have another clip already for you guys that says we're not going to watch the whole thing. We watched the whole thing. Okay. I'm going to give you my quick thoughts on that, and then we're going to move on to something more positive. We're going to end on something positive because that's how this is going to go. So, that comment that you made, I'm going to say your name because you just put it up there. Mabel. It just, I guess in a sense, what I'll tell you is this. It just makes me realize what I've been working through therapy, and realizing why I became the way I did with people and how I became so passive, and how it wasn't good for me to be passive because I was so scared of saying my piece because I thought that I would get the reaction like that. Now I'm talking about the littlest of things. So it does feel good. And I share this with you guys because that's the whole point. That's the whole reason we've talked about this stuff on the podcast and we've been vulnerable, is I'm sure some of you have people in your life or your parents are like this, and it's just tough. But I will tell you right now, with how much she does that, there's no way we're going to watch this on a regular basis. I can't sit through it. There's so many obviously emotions that go with it, but on top of it, even just from the outside, if you're looking in, it's tough to listen to her talk. She's so rude, and I feel really bad for the judge, and I hope I just feel bad for everybody. I feel bad for everybody involved. So we're gonna leave it. We're gonna leave the Lori talk there. My next point, and the last thing I was going to end on real quick, is I've been wanting to make sure that we have some positive things. And one thing I wanted to just remind you guys, something that I've been learning lately, is just really recognizing little wins. So the last week, I've kind of posted on social media, on my Instagram if you haven't seen it, but I started doing a 90-day kind of disciplinary thing with, because I've had a really bad diet lately, and I have really tried my best to get a hold of myself. And so I wanted to talk about celebrating little wins and little things like I have a really bad sweet tooth. And so I will go for the sugar and I'm going to go for the salt so I can balance out the sugar. You know how it goes. I'm going to grab me a drink, okay, a little slush or something. I'm going to go for this and go for that. So I definitely emotional eat, number one, and number two, I just struggle with that kind of stuff. So I'm sharing this with you. Celebrate your little wins. For me this week, I haven't had any real sugar at all. I've been doing a disciplined routine of basically Kelsey and I and my friend Garrett, who you guys have seen on here too, are doing this routine where basically you have rent paid by Sunday, and it's 500 push-ups for the whole week. So you have the whole week to do this: 500 push-ups, 500 sit-ups, 500 squats. This is all body weight stuff, and then 50 pull-ups and 3 hours worth of cardio, and then eating clean. And I'm telling you guys right now, I share this with you because I was feeling so bad about, like, I physically felt so bad every day at work. I felt so like tired, like overly tired, like to the point where like I can't function the way I need to. I don't have the energy. I don't feel like I have anything to give anybody. And so I'm telling you right now, I have never felt so much more up, like just eating chicken and just prioritizing a lot of protein. Kelsey's told me to eat in the morning because I was really bad at that. I would always just eat really lunch. I'd always skip over breakfast. And it has been life-changing. And what it taught me is mental discipline and the fact that I can do hard things. And I did set the bar high for myself and for everybody that I said, if you want to do this, we're going to do this the right way. And I'm sharing this with you because it helped me so much. And I have always had struggles with eating since I was a kid. And it really ran a lot of my life and my decision-making and how I felt about myself. But more than anything, it's just I'm realizing life is about that mental fortitude, and realizing that when you get to show yourself that you can control your impulses and your urges, it has an actual physical reaction. Like I feel so much better, and I have a lot of energy even when I'm exhausted or we didn't sleep well because the kids are up or whatever the case is. I'm telling you, it's helping me, and it's helping me have a clearer mind. It's showing me that I can have the discipline that I put on myself. No one's making me do it. And this was a tough thing. Okay. We went to Cheesecake the other day, and I'm out with the boys. We're at Cheesecake, and I said no to the cheesecake, and it was tough. And I ate my chicken Caesar salad because, first of all, don't even start. Everybody's like, "Oh, you're getting a salad? Shut up." Okay. I loves the sugar. I loves the Louisiana chicken pasta. I'm going to get it every time. But I actually really love the chicken Caesar salad at Cheesecake Factory. So I was fine with that, and it was good. So long story short, I'm just telling you, celebrate the little wins in your life. This doesn't have to be about food. This doesn't have to be about workouts only, but just try to celebrate the little things that you do every day. You should probably, one thing I will to say is set goals for yourself and really realize that you are capable. You are sitting here capable of so much more. You just have to find a way to kick yourself in the butt. And yeah, it's great to have people around you that motivate you or keep you accountable. But I'm telling you, there's something about saying to yourself, you mother hecka, you ain't having no more candy at night. You're not going to late night snack. You're not going to eat a whole bag of chips. I can't even tell you how bad it is. I can eat like no other. I love to eat. It is a serious problem. I can eat all the time. Celebrate the little wins. Exactly. You got to do it. You got to start looking at yourself. Because think about this. Every day you go through your life, no matter what you're doing in your life, whether you have your kids, whether you have grandkids, whether you're just working with your spouse, whatever the case is, you don't get a lot of recognition. Okay. Not everybody's going to work and everybody's like, great job today, you know? And it's not that you need that, but it's like when you tell yourself, I know I did something hard. I know I accomplished something today. And I know that I can do hard things. You will continue down the right path. And this is another big point too, is like little things like making your bed. I don't make my bed, so I'm not going to cap on that. But the point is it's a discipline. So celebrate the little wins in your life. Know that you're loved. You do have self-worth. You need to know that. You don't need to even question if you are worth something, because you are. And we just try to be better, 1% better every day, and try to be better people and try to make better decisions. And when you fall, just there's no time for us to be crying and mad at ourselves when it's our stuff. Just get back up, and you got it. If you do want to know anything more about the fitness stuff, I'll be posting more of that on Instagram. So that way you guys I can give you guys tips or whatever the case is, because I love talking about fitness, but I won't do it all right here right now. But it's been life-changing for me. It's only been a week, literally, and it has been seriously. It's been incredible. I feel good. So that's the big thing. If you got to feel, when you feel good, life is easier. Anyway, I wanted to say thank you guys for watching the episode. Thank you for sticking with me through an unexpected, funny trial. And also thank you guys for I think we had a lot of orders on the merch, so I appreciate that. I hope you guys love them. Please send your pictures if you're comfortable with that. I'd love to know what you guys think. And if you do want to know about the merch, I did see that earlier. I was going to just answer it now at the end. We do have it on the store on the main page, so you can see, you guys can choose. There's Warrior stuff in there. There's the Star Wars podcast stuff. And then there's Kelsey's little flavor in there. Kelsey's got her stuff in there too. So it's pretty good, but I appreciate you. Love you. I'll keep you guys up to date on the community tab, and yeah, have a great night.